Hello, everyone. Obviously, since Ed and I posted our last video, we got a enormous amount of views on that video and a ton of comments, a ton of questions. And I think that as we look through social media, we look through some of the different channels that we have access to. Ed and I have both come away a little bit concerned with some of the misinformation that may be going on out there. And we just thought it might be a good idea for us to get in front of you again and give you an idea of what the settlement actually says instead of what people are saying it says. We are going to go through some of the key elements of that settlement and talk about, some of the different things that could be occurring over the next couple of months. One of the number one questions that we've gotten that I just want to say at the beginning, and I'll probably reiterate it when we go to the end, is that day to day, nothing changes for our brokers and our agents. Until the settlement, and recognize that this is a proposed settlement, the judge in the Burnett case is not even given a preliminary approval at this point. So a lot of discussion about things that may be fluid, may change. We would hope to have a better idea before the July timeframe that they've put into the agreement to have this occur. But just recognize that until then, there'll be no changes to the multiple listing service. There'll be no changes to the compensation field, and it should be business as usual for brokers and agents, with the exception of preparing for some things that you guys need to have some ideas of what's going on. So I would like to dive into what the settlement actually states. Ed and I are going to take some elements of the quick summary and go through what is actually in the settlement. The first one that I think that may have some changes for you now, because I do think you need to get prepared and be aware of buyer broker representation agreements. But part of the proposed settlement is that there's going to be an MLS rule that agents working with the buyer must enter into a written agreement before the buyer tours any home, and it must have these specific terms. There must be a specific fee to be paid to the buyer's agents for their services. That fee must be ascertainable with no games, no ifs, ands, or buts as to what that fee will be. And a buyer broker may not receive more compensation from any source that exceeds the amount or rate that is in the agreement with the buyer.
Yeah, thanks, Art. The next aspect of the settlement agreement that really applies to us here at the MLS also is that any existing MLS rule and any existing fields where we accommodate for this offer of compensation with regard to a blanket unilateral offer must be removed. So again, after there's finalization of these rules and some timeframes have been established, we will be removing some of those existing rules and those existing fields.
There's also going to be a new MLS rule that prohibits the listing broker and sellers from making, one, an offer of compensation on the MLS to buyer brokers. So you can't use the remarks field or some other element to offer compensation on the MLS, or disclosing on the MLS a listing broker compensation or total broker compensation. So the combined comp is not allowed. Ed, talk a little bit about what the MLS can require on this new rule in Section 3.
Yeah, so what's absent from this requirement is the MLS can, just like we do today, ask the listing agent when he's reporting a closed sale, what was the actual amount of concessions that the seller provided to the buyer. And to the extent that those concessions may have included some kind of buyer broker fee, that could still be requested and identified within a closed MLS listing. In other words, that's factually what actually happened. I think the reason that that is allowed to remain is because it's going to impact value, right? This is important information for you to have as both the listing agents and representing buyers. So when you run a CMA, hey, what property resulted in some type of seller concession versus which properties did not. And that may impact some of the decisions of your sellers and buyers and how they value properties. So I think this particular section, it's important to note what's not here. and what we're still allowed to do, which is to ask at the closing, what was the actual amount of concession given from the seller to the buyer? And that will still be allowed.
Okay, and it also talks about some of the things that the rule shall not prevent. What are some of those things, Ed?
Yeah, some things that we're not allowed to kind of make a rule, rules that we can't prevent from happening are offers of compensation off of the MLS, right? So again, this is kind of consistent with the overall philosophy of MLS rules, right? We're here to regulate and to manage our broker cooperative within the multiple listing service, but you guys still have the freedom of contract outside the MLS. So any kind of deal that gets cut, not involving the MLS at any level, is still out there for the brokers to engage in, kind of whatever deal making off MLS that happens. The other thing that's important to note here, and a really critical exception, is that we are not prevented in the MLS from having some kind of field that allows the seller to communicate a concession. Now, this is very different than a unilateral offer of compensation. What's allowed to happen is the communication of concessions that the seller says they're willing to do in the list price. As an example, at CRMLS, we noted in 2023 that almost 50% of our closed transactions had some level of concessions, meaning the seller paid for some level of the buyer fees. Now, if you guys remember 2023, we had high interest rates. So we saw a lot of loan buy downs, right? Where the sellers helped the buyers get into the property. We saw a lot of sellers paying for title and escrow fees on behalf of the buyer, again, to encourage a buyer to come buy their property versus a different property. So the concept that the seller can still create an incentive directly to the buyer is completely allowed and permitted within the MLS, because it's not a formal offer or a contractual offer of compensation to the broker.
So obviously in some of the comments and some of the things we've seen on social media, just the idea of creating this element outside of the MLS where there's this aggregated mechanism to provide offers of compensation. There's some issues that will be in the settlement agreement to stop some of that activity from happening, because we're going to agree to not to create, facilitate, or support any non-MLS mechanisms, including sending any listings to internet aggregator websites for listing broker or sellers to make offers of comps. But the MLS can provide data to a site unless the MLS knows that the data feeds are being used for the purpose of operating a platform for sharing comp, or the listing broker is displaying both data from the MLS and offers of comp only on that broker's specific listings. Unpack that one for me, Ed.
Yeah, this one's a little complicated in its wording, but here's the scenario that I think was anticipated, or the concern as the parties were settling. And that was, so we have this big rule that applies to all the MLS across the country, that we can't facilitate or have a field that offers compensation from broker to broker, right? But what would prevent one of these big data aggregators or the large portals that everybody goes to from basically just offering an opportunity for listing brokers to go into their listings and drop in an offer of compensation anyway? And so in other words, you would have the same facility, the same issue out there, just not in the MLS, right? And that really wouldn't be fair. The concept here is we're limiting this opportunity on a grand scale. So this particular aspect of the settlement agreement is a rule that on us that says we're not allowed to even send the listing data to a company or to a firm that is using the data in a way to, in essence, mimic what is prohibited in the MLS, right? Now, that being said, if you're an individual listing broker and you get a data feed from CRMLS, of which there are 27,000 of you operating a website, nothing prevents you on your own listings only from having some kind of offer of compensation to whoever you want to help, bring a buyer. So here, I think this has got more to do, Art, with the kind of the freedom of contracting again, that some of these rules have to still have guardrails on them, that parties still have the freedom to enter contracts. But what you're not allowed to do on your website as a broker is to have offers of compensation for listings that are not yours. If you do that, by rule, we at CMLS are going to be required to turn off your data feed, right? So it would only be an offer of comp on your very own listings.
Okay. Very good. So those are the basic facts about what we've seen out of the proposed settlement. And I think it may be a little bit different than what you guys are hearing out there. Obviously, to transition, we're hearing a lot of common questions and misconceptions about that settlement that we just read off for you guys. One of the ones that first one we hear is, how could NAR do this to us? And obviously, not being on the front lines and not being the ones that have been dealing with the plaintiffs, there's just a wide variety of pressures and issues that NAR has been undergoing in all of these lawsuits. The Burnett Sitzer lawsuit and the loss in front of that jury trial obviously had a lot to do with that. But Ed, talk to me a little bit about a former litigator, what could have enticed NAR to do and to go this direction?
The first one is the facts in the law, right? Everyone gets kind of grandiose, and I think maybe we watch a little bit too much TV drama on what lawyers can do. And there's this like misconception that whoever has the best lawyer wins. That's not how our system of justice was designed. That's not how it operates in reality. Okay. You have to deal with the facts and the law as they exist. No matter what you want, the truth is still supposed to be what happens. And so the reality is the industry system that's been in place for 30 years, 40 years, went to trial and this side lost. That's the reality of it, right? A jury looked at the facts, it looked and applied the law, and determined that there were problems with this offer of compensation in the way that buyers don't have an opportunity to negotiate their side of the transaction. And so that was the decision that was made. And so NAR is forced to deal with that reality, that they tried the case and the concepts and the ideals lost. And so what do you do next? And so NAR shared with us a little bit about that in some of their frequently asked questions they published. And that was, come April, with these post-trial motions that were there, if NAR was not going to win those, realize, Art, what was going to happen next was, one, there was going to be a very large judgment put against NAR. There was probably going to be some kind of bond hearing that would have required NAR to post a bond in the hundreds of millions, if not even $1 billion, for which they may not have been able to handle, which means NAR would have had to file bankruptcy. Now, the moment NAR files bankruptcy, guys, realize NAR cannot participate in resolving any of these claims against anybody. They can't contribute any money, and they can't help resolve anything about the rule. The other danger, Art, that I think NAR was facing come April was a motion from the plaintiffs to the judge in the Sister Burnett case requesting that an injunction be placed against NAR to change the rule. So guys, realize in that environment, one single judge in the state of Missouri would have been then writing the rule that we were all going to have to follow. And it would not have included any of the nuances of the 5 points, Art, that we just articulated and went through. We talked a lot about, hey, here's some things we can do and some things we can't do. Right. And the reason that a negotiated rule set is better for the overall marketplace is it does keep alive a lot of the concepts of transparency. It helps agents with this mandatory buyer rep agreement because we know a lot of times that's not done. And so if you have some agents doing it and others not, how do buyer agents get paid? Right. There would be a lot of problems if we had just a judge-made rule. So I think those are probably the two biggest aspects of, why did NAR, decide to settle? Look, they lost and they were really up against, being able to not help the industry at all if they had to file bankruptcy. And so I think they pulled what was the most logical position and strongest deal they could get cut.
People view this as a bad deal for real estate, but it could have been much worse, couldn't it have?
Oh, it could have been a disaster, right? Imagine, guys, a rule that says 30 days from now, every MLS just has to pull the compensation field out, and that's it, nothing else, right? Think about the bedlam that would ensue. Think about, again, here in California, where most people don't get buyer rep agreements signed. How do you get paid, right? And with no requirement, you'd have some agents doing rep agreements, others that wouldn't. So it might be hard to get one signed, which means the question of whether you're going to get paid at all. Does it move the offers of compensation kind of into the back door room, right? Where depending on how good of a friend you are with the listing agent dictates whether you get a cut of that action or whether you get nothing, right? These were all the way our world would have looked like if NAR didn't try to resolve this. And let's not lose sight of the fact that the release that NAR got was for all of the local associations. Obviously, us as MLSs are protected because, you know, we're in a lawsuit right now. And so we end up with protection. And NAR's release includes every single Realtor member, right? There is a group of about 95 brokerage firms that are not covered by the release. They did cover 1.6 million individual agents in getting this deal done, right? So it's not like that is insignificant, right? That's a major protection for those of us that are realtors and day to day, you know, practice real estate.
And obviously, you know, if all of the cases had gone to its, you know, final ending point, and we would have lost, it could have bankrupted most of the industry. So I think there's some important things to realize on that side there. We're hearing a lot of this is the end of real estate, end of the road for real estate as we know it. There's some truth in that, but you know, recognize that there's some misleading articles out there as well. Real estate as we know it, which means an offer of compensation in the MLS, will be coming to an end. But you know, recognize that compensation is not currently required in the multiple listing service. That zero is a number that was allowed per NAR earlier last year. You know, it is our belief though that real estate will thrive, and you guys are, you know, very, very good at adjusting the way that you do business. Ed, talk to me a little bit about what you think, you know, some of your experiences on the commercial side.
It's interesting when people say real estate is going to end as we know it. You know, my personal career with real estate included quite a bit of commercial. So for me, I look at these changes and go, I'm just going to get paid like I do on a commercial deal. And by the way, when I close a commercial deal, the closing statement on a commercial deal, if I laid it next to one of the deals on my closings on a residential deal, look exactly the same. And what I mean by that is the seller paid me as the buyer representative my fee. The difference between the two is when I do a commercial deal, my offer includes the seller paying the buyer agent fee, my fee. And it becomes a point of negotiation between the buyer and the seller against the list price and other terms. And so there might be a little bit of back and forth on how much of my fee the seller's going to cover. But I can tell you guys, 95% of the time, the seller has paid 100% of my fee on the buyer side. That is the norm, even though there's absolutely no MLS, there's no offer of compensation, there's no unilateral contractual rights that I have as a buyer's agent when I bring a deal. And trust me, guys, today there will be thousands of closings that happen in the commercial world where there's no MLS, no offer compensation, and the buyer's agent just got paid by the seller. I think the real focus here is going to be changing some forms, making sure you're properly educated. Guys, go out and get some of your negotiating skills up to, you know, a high level. I think the other thing we're going to see here, Art, when you talk about changes in real estate, I had one person ask me, well, so, hey, Ed, what's going to happen with buyer agent fees? What do you think that's going to look like? And I said, I don't know. You have to give me a lot more information. And what I'm going to need to know is how experienced is the buyer's agent? Realize one of the things that's going to happen now is me as a 30-year lawyer, 20-year realtor, I am going to be able to command a very different price for my services than somebody who's been a realtor for 20 days, right? And that's, guys, how it works in every other field. As a first-year associate lawyer, I did not make as much money per case I worked on as the named partner whose name was on the door, nor should I have. Right. So there are some opportunities that are going to be in here. And that is going to also be a different. I think you're also going to see differences, whether you're in a buyer's market versus a seller's market. That may also have a little bit more influence on the level of commission and rate of commissions. That is going to be a little bit more tied to, a capitalistic market-based approach than it maybe had been in the past.
Yeah, the other thing you're hearing, Ed, is that buyer's agents are going to suffer the most. And actually, buyer's agents are going to have the opportunity to explain their unique value, their proposition, and to their buyers. And they're going to be given an opportunity to place a value on the buyer agent services. And those buyers are going to be able to accept the obligation to pay for those services. A lot more transparent, a lot more of a clear direction to the buyer as to who's actually paying for those services. Talk a little bit about that, Ed.
Yeah, I think it's an important distinction. I think this is actually a great opportunity. We've all been taught in real estate, you become a buyer's agent to do the hard work, the go tour a bunch of properties, put in lots of different offers, just so that you can develop a relationship, so then you can become a listing agent, right? Where all you do is tap the sign in, enter into the MLS, and voila, I get 6, 7 offers above list price, right? That's everybody's goal. Realize, guys, now think about this hot sellers market we were just in. Imagine the very best buyer's agent who can demonstrate that they get their first offers accepted on a very high level. Why can't that person charge a premium? Right? They're not stuck with whatever the listing agent and the seller thinks that buyer's agent should get. They can command a level and a brokerage fee that stacks up against their skills and their expertise. And so can you actually receive a premium as a buyer's agent? I think actually, Art, in a hot seller's market, one of the things we might see in the future is a lowering of the list side, right? Because now as a seller talks to a listing agent, the communication, the conversation is about the services the listing agent is going to provide, and the hours and energy going to be spent by the listing agent talking to the seller. It's not going to be confused or bound up in how much of this do we have to give to the buyer's agent, right? And so in a hot seller's market where it's not as challenging to sell a property, is there some downward pressure on that side? I think you're going to see some of those kind of things reshift a little bit. So I do not agree with these analysts, from Wall Street who've never walked through the house with a buyer before, who say, "Oh, the buyer's agency will just go away and no one will pay for those services." Trust me, buyers want representation. They want great representation, and they will pay for it.
Yeah, and I think it's important to note that, statistically, everybody's looked at the, insertion of the internet and, buyers and sellers being, more empowered to do a lot of this work themselves. But, statistically, what we've seen is a significant rise in the amount of people that are using the services of both buyers and seller agents. So, that may be counterintuitive, but I think people recognize that it's a very complex transaction, and one that they need to be, represented through. Nobody will go into court and have an expectation that the lawyer that's representing the plaintiff is also going to represent them on the defense side. So, recognize that I think there's some very, clear understandings from the consumer standpoint as well. We're also getting, if the proposed settlement is approved, when will the commission field be removed? Obviously, there's a lot of moving parts. We mentioned that in the last video. There are rule changes. There are potential lending law changes that have to be made. There are forms that have to be changed, forms that have to be created. But recognize that we're going to do everything we possibly can to communicate with you guys as much as possible. But for now, it's business as usual. There's not going to be any changes in the MLS, and no forms changes until the settlement is final. And as NAR has noted to everyone, that could take months. And if the changes actually occur in July, I'd be surprised. I don't quote me on saying that they won't happen in July, but there's a lot of moving pieces and a lot of things that have to be addressed before these changes can go into effect in the multiple listing service. So in closing, I just wanted to kind of reiterate to you guys that CRMLS has not been planning for this, but has been aware of the potential of these changes for a long time, for at least 3 years. I'm a big believer that you've got to do contingency planning, and those contingency plans have to go from worst case scenario to best case scenario. And we're pretty close to where we thought things were going to be, and we're prepared to act as far as what the changes that are finally approved in the settlement. I just would recommend that everybody, calm the temperature down a little bit. Let's look at how we can embrace the opportunities ahead. We're going to continue to help you and enrich your understanding of all the changes and what it means to you on a day-to-day basis. And I would highly recommend that you guys subscribe to our YouTube channel and be notified of new updates from CRMLS, because we're going to be pumping things out. And we understand that there's going to be a lot of need for education and a lot of times to have an understanding of what all these changes will mean to your day-to-day business. And we're going to do everything we possibly can to not just bring CRMLS's voice to the table, but all of those people that could help you understand what all of these changes that will work their way through all of the escrow channels and the lending channels will mean to you guys. So thank you guys. Thank you, Ed, for taking the time to try to hopefully make this a little bit clearer for everybody. Obviously, we're making it as clear as we're able to at this point. And I just really recommend that you guys stay tuned and pay attention to all of those different communications that are coming out from CRMLS, from NAR, and from the California Association of Realtors. Thank you, and we look forward to talking to you guys again.